All right, last one of the unit, civil liberties, civil rights. One more time, Unit 5, Video 14, affirmative action cases. All right, so what happens here? Remember, affirmative action, preferential hiring and admissions policies for minorities. So because there had obviously been lots of troubles with minorities not having equal opportunity, then affirmative action comes along to try to help that. Now it's going to be limited. We still have affirmative action today, but it is not as it originally was. You have this first case, Regents of University of California versus Bakke, 1978, which said that schools cannot use a quota system. What a quota is, it's a specific number of people who are seats set aside for minorities. They were not allowed to do that, so they could not say, for instance, that there were 30 seats out of 100 specifically for minorities. That was no longer allowed, but they could still give or use race as one of their qualifications. Okay, so we still have it, just no quota system. Now coming up a little bit closer in time, we have Grutter versus Bollinger. This is involving the University of Michigan. And what happens here with Grutter is you have where they say that race can be used as a factor, but not the factor when it comes to admission. If that sounds like something that is impossibly tough to actually enforce, how race can be one of the factors but can't be the main factor, then you are not alone in being confused by that, because it basically is a meaningless statement. But that is what the Supreme Court said there. In a companion case that they heard alongside of that one is a case called Gratz versus Bollinger. Again, same thing, University of Michigan. And what this one ruled is that schools cannot use a point system and award points for race. So, as a very brief version of this, what happens, some schools, when they're choosing whether to accept you or not when you apply, they award you points for your GPA, and they award you so many points for an SAT score and more points for a higher SAT score, and then they award you some points for your extracurriculars and all that stuff, and they add it all up, your letter and recommendations and all that stuff, right? They add it up, and if you get enough points, then you get accepted to the school. If not, then you don't. That's allowed. However, they cannot give you points for race. And what University of Michigan had been doing was that they were giving a lot of points for race. In fact, you'd get more points for simply being a minority than you would if you got a perfect SAT score. And so that's what the Supreme Court was not allowing to happen. They can still use race, but they cannot award points for race. So again, the main takeaway from affirmative action is it does still exist. We do have it. Race can be a factor, but not the factor. And you can't award points for race, and you cannot demand a certain number of minorities set aside those seats for minorities. So no quota system. And that is what this is saying here, as currently interpreted. So there you go. There it is in written form. And this has been a La Money production.